Dave. I'm a realtor, specialize in multifamily properties, pretty much of all sizes. So I'm here to learn, meet some new people, and then also I want to buy a duplex here in the next few months, so that's pretty much it.
Hey y'all, I'm Sandy. Oh yeah, my last name is Lee. I'm here because we have 9 units. We come upon every incident ever. I'm just really here to learn and to share with you guys all the things I messed up on, and just to be better at it when it comes to legal stuff. Long term, to be quite frank, I had several friends die in their 30s, and so I realized life is really short, and I don't want to do things when I'm like 60 and have bad news. No offense if you person.
Bad news.
Okay, but yeah, so I really just want to live my life now, and I think real estate is a great tool. My parents are refugees, and they were able to own and build their own property, and I really want to do better, honor them by doing better. And so real estate is just a tool. Long term, I want to have income so that I can do long term legislative work around neuroimmune disease, and also be a real estate prosecutor.
Hi everyone, my name is Tristy. My husband and I have 3 units. Here to obviously learn more about the landlord law, how to protect ourselves, how to be a good landlord, not a slumlord. And our next goal is to buy another multifamily.
So this goal is here to learn as much as we can from get motivated from all seeing all these people working in the same field. So that keeps us going. So yeah, we are working hard.
I think our main driver is not to have to just keep on counting on the 9 to 5, right? So that we have more free time to do what we really like to do, other than just working as well.
Year after getting more done.
Yeah.
We're trying to get more happy for ourselves. Yeah, that's all.
Hi, my name is LZ. I actually deal with quite a few tenants. My day job is property management. I manage about over 1,300 units right now. So I too have experienced some of everything. Right now I'm in a single family home in a triplex that I acquired in April. I've been house hacking my way into freedom, and I want to continue that trend on an annual basis. Basically, for like Sandy said, legacy reasons, and having the option, as Gordon points out, to retire if I want to before I die.
My name is Johnny. This is my wife, Krista. All the reasons everyone said, that's what we're here at the same time.
I'm Krista Nelson here with Johnny. Just want to learn as much as we can, and we're about to list our flip in North Dakota, so that's exciting. We're ready to get that sold. So.
All right, guys, thanks for coming. So I kind of going to leave this up to Sam because he knows the subject quite a bit better than I do. I'm a landlord, but have no background in law. I think I want to preface everything with that, but I'll let him take it from here.
Let me fire this up. So, not through any fault of Jordan at all. It's sort of a very broad topic, landlord-tenant law. I came into it kind of with the approach of. So that's my day job. So I work at a company called Night Owl Discovery. I do electronic discovery for big companies, kind of like IT stuff. So we collect their computers, we do all the processing, all that. So I work there from 8:30 in the morning till 5:30 or so at night. And then my second job is working for the Hoffner firm. So we do, like I said, we do criminal defense, license defense. So we do rental license defense and things like that if anyone ever has issues with their rental license. And Fabian's actually an admin law judge and hears housing issues. So there's kind of some conflict stuff that comes up, but generally speaking, we can assist with that kind of stuff. And then third, sort of just like most attorneys that do solo form work, it's kind of a jack of all trades, can type thing. So stuff comes in. If we don't know it, we figure it out. If we don't think we can figure it out, we refer it to someone else. So since I started practicing, the main issues that have come up for me in terms of landlords and property owners approaching me with questions were twofold. I actually haven't dealt much with the shared utilities, I'm sorry. I know some basics about it and kind of how it functions, but in terms of like specific legal questions, and if anybody does have a question and I don't know the answer, I'm pretty good at just saying, I don't know. Let me preface all of this by first saying the standard sort of legal disclaimer that nothing that I say here is legal advice and no one should go and rely on this for anything. If anybody gets into trouble, I'm not responsible. So let's just leave it at that. And that's, as you all know, that's kind of what we have to say whenever we're talking about these types of things. But I've had two kind of broad areas, and I didn't really get into the second, but we can talk a little bit about it because I do know there was a question about sort of LLC structures and corporate structures and how to set up holding companies for your properties. I've done a couple of them. I'm not super well versed in sort of the accounting and insurance aspects of it. So if you are planning on doing something like that, your best bet is to have sort of three people looking at it, right? You want to have a CPA, you want to have an insurance agent, you want to have an attorney looking at it. Because there are insurance aspects of it that I'm just not going to know about. There are tax and accounting issues that I'm just not going to know about. As far as the actual structuring of it, where do you file things with the Secretary of State? How do you set up an S Corp with the IRS if you want to have like an umbrella or like a holding company over the LLCs, depending on how many properties you have? Do you just want one LLC to protect your own personal assets from liability if somebody should, God forbid, slip and fall on your property or cut their foot off with a lawnmower or something like that? And we'll get into a little bit of that sort of separately, but I do know some about that, but it's not really my forte, but it is something that, like I said, I'm familiar with the setup and doing things like that, but in terms of the, hey, should I have, 3 LLCs in a holding company? Should I have 4 separate LLCs? Should I put everything in one LLC? It gets into a lot more complicated stuff, and as anyone who's tried to set it up probably knows, it starts, with the web sort of grows and it gets pretty complicated pretty quickly. But we can talk about that, and it's not really part of my presentation either, but I figured at the end, I kind of have my last slide of questions, and I didn't add text. So I didn't know what was going to come up. So again, my name is Sam Merritt. I work for the Hoffner firm. There's my email address, there's my phone number. I've got business cards if anyone needs them, but so right off the bat, not legal advice, but I will talk about some things that have come up both in my own property management, dealing with tenants. So for anyone that didn't hear, I got into the property business about 5 years ago. My wife and I were living in a rental apartment in Little Canada. We weren't married at the time. She went and saw her grandfather. He's a farmer. He said, you need to buy property. He's worth like $1.5 million, and she said, this is what I want to do. So that was November. By January, we owned a duplex in Crystal that we bought with an FHA loan. Moved into that, half of it, rented out the other half. It came with a tenant. He was fantastic. He took care of things. He fixed stuff. He was really handy. He wasn't loud. It was just him and his little boy. It was great. About 2.5 years ago, we moved out of that unit, rented it, we bought a top-down duplex in Powderhorn, 3-bedroom bottom, 5-bedroom top. We moved into the 5-bedroom. By this point, my wife was pregnant. We'd been married, and it was a nightmare. So we can talk a little bit about how that went and sort of the process that we went through. Again, it came with tenants. So if anybody is familiar with kind of how that works, when a property is sold, if you sell a property where you have tenants, kind of the things that go with that. But we inherited these insane people and had to deal with sort of some of the ins and outs of eviction and dealing with health inspectors and being in court and having them file things against us and us file things against them, and it became quickly a pretty complicated and painful experience. So then, since then, we rented out the bottom of that unit. We moved out of the top unit about 3 weeks ago, bought a house in Victoria, and are looking to buy $4 or something like that within about 3 years. We've got sort of an investment strategy to save up enough for a down payment. And we can't, unfortunately, use the FHAs anymore unless my daughter really wants to buy a house. So we're gonna have to come up with 25%, but that's, I think everyone is probably familiar with some of those rules and how that kind of works out. So I split this up into sort of the common issues, things that people have brought up to me when they had questions. Some other issues, just general law stuff that people sometimes aren't familiar with that I've run into or have had people ask me about also, and then a Q&A section at the end. So the most common areas where people get into trouble are the things that come up when dealing with landlords and tenants are kind of in these main areas. So screening and rejecting applicants is one issue, and if anybody is familiar at all with kind of the current goings on at the Minneapolis City Council, there are some changes that are, hopefully not, but potentially in the works that would make life a little more difficult for us. Advertising, dealing with security deposits, the sort of makeup of the lease. I didn't really get too much into custom leases. For the most part, your typical landlord is going to be, even your bigger landlord, is going to be pretty well served by just the standard Minnesota lease with some modifications for particular things that you want to do in your apartment or in your units. You can take that, it's downloadable, it's pretty easy to use. You can make insertions, deletions, you can get it as a Word document, you can add things and remove things. You're generally not going to get into much trouble unless you start putting in unconscionable clauses, and we can talk a little bit about what those might look like. But generally speaking, that's kind of the way to go. It's the thing that they, when you get into housing court, if you've got this sort of jury-rigged, custom-made lease that you made up yourself on your Word, on your computer, you're going to get looked at a little sideways by the judge when you get out there. If you've got the standard lease that you downloaded from the website, they've seen that a million times and they know the kind of ins and outs of that. And it's got, the little things in there that kind of will protect you when you do get to housing court if it comes to that, or if there are issues that come up with tenants in other ways, like maintenance issues and things like that. Issues with rent, maintenance, and then finally a kind of a section on eviction. So screening and rejecting applicants. So everyone here, I think, with the exception of a couple of people, has rented out properties in the past. Generally speaking, the process is that the tenants come to you, or the prospective renters come to you, and you take a fee from them, you run a background check, and decide whether or not you want to rent to them. So a couple of things that most people don't get into trouble with, but there have been some people that have, is that you can't accept more than one fee at a time. And so what that means is that if someone gives you a fee for a background check, until you reject that applicant, you can't take a fee from someone else. And you guys got to forgive me if any of this is blatantly obvious and everyone knows it. I'm just kind of going to cover some stuff, and then you take what you want from it and leave what you don't. When you do take a screening fee from someone, and this will kind of dovetail with the ordinance and sort of the inherent conflict that we have with both the screening process, the proposal that the city council is making in Minneapolis, and also the rules with regards to landlord liability for the criminal activity of tenants. Not necessarily landlord liability for the criminal activity, but threats to your license because of criminal activity. So there are rules in Minneapolis, there's an ordinance in Minneapolis that landlords their license can be threatened if they allow criminal activity to take place on their premises. There's a pretty basic conflict there with, you have to rent to criminals, but if criminals do criminal things on your property, you're gonna lose your rental license because of it. But we'll talk a little bit about kind of how to deal with these things and what you should do. So a couple of things. So screening criteria, if you're going to use a tenant screening process, you're gonna pay a company, you're gonna give them $30 and they do the screening and send you the reports. You have to tell them beforehand what you're gonna use as your criteria for rejecting something. So that would be, if your credit score is below a certain threshold, if you have convictions for a certain number of crimes, or if you have been to housing court. These are kind of the three primary things, and also the three things that they're thinking about getting rid of are, criminal history, credit history, and past experience with eviction courts.
And ability to repay.
Ability to repay meaning?
Ability to pay the rent.
Yeah, I guess I take that as kind of a part of credit history, but yeah, income thresholds and percentage of monthly income that would go under.
Sorry, did I hear you right? You said they're talking about taking away a screening criteria that was a credit. Did you say that?
Yeah, and I'll talk about that in a minute.
Okay.
And again, I don't know that they're going to do this. It's one of those things that people propose crazy stuff all the time. There are some communists that are at the city council that really just don't that aren't friendly. I mean, it's sort of like, and I don't get into this here, but but we can talk a little bit about it. The rent control. I mean, that's a kind of a perennial issue that comes up. It's impossible to really talk about without the specifics of a particular program. I lived in New York City, so I have some experience with how rent control works and why it's a terrible idea and a nightmare. I don't think it's going to happen though, so I didn't even include it here. I just think that's dead in the water. This other, these other proposals, I don't think have a chance of passing in their current form, but I wouldn't be surprised if there are some bits and pieces of it that kind of filter their way in. So it's something to keep an eye on, and it's relatively recent. I think they proposed it in May, so just last month is when it first came up. So just a couple of points. If you reject someone for a reason that's not on your list of criteria for the screening, then you have to refund their fee. And we'll talk a little bit about why that might be worth it, just to kind of have a little peace of mind about whether this is going to come back and haunt you. The odds of anyone here or any landlord, particular landlord, getting in trouble for, short of like really blatantly obvious stuff, which we'll talk about, but the odds of you getting in trouble for rejecting someone for one of these reasons is actually pretty slim. But there's really no reason to get into it if you don't have to. So, the question is, should you give a reason when you're rejecting someone? You don't have to give someone a reason for anything. The only time you need to give them a reason is if that's why you're rejecting them and you just want to tell them this. And part of the issue is that if you tell them the criteria beforehand, and they still apply with you knowing that they don't meet the criteria, it's sort of an odd situation where, and tenants do it all the time. I mean, we tell tenants, we won't accept you if you've been evicted in the past 2 years, and then they send, they put their application in, we pay the screening fee, and they were evicted the last year. I think that they think that, once they kind of get their foot in the door, they're going to work it out with us, and it's going to be great. But you're still pretty safe just telling them, if you've been, if you've done this, you're going to get rejected. A lot of times they'll just say, well, no, I'm not even going to apply, and then you don't have to pay the fee, you don't have to go through any of this. And bottom one should go without saying, don't be racist. Basically, don't reject people for a protected category. So, the protected categories are, race, pregnancy status, age, things like that. Don't reject someone because of that reason. And if for some unknown reason you do, don't tell them that.
Quick question. If you don't take a fee, right, you can screen as many applicants at the same time as you want. It's all just related to the fact that you're taking a fee.
All related to the fact that you're taking a fee. You can screen people if you want. I mean, if they give you their information and you want to pay out of your pocket to screen people and see what they're like. But
There are federal laws around it though, you still can't discriminate, so.
Clearly, no.
Oh, no.
But I mean, if you're shopping for better offers or whatever, right? If they do
No,
something like chicken
no,
wings,
that's what I mean though, you can't, so, the federal law does not allow you to shop for the best offer. When someone meets your criteria, you have to accept them or you just discriminated, end of story.
well, discriminated based on what though? So you can't discriminate based on protected categories, but you can discriminate based on anything else. So as long as you're not discriminating based on something that's protected by federal law, so disability status, race, pregnancy, there's a handful of things that you can't discriminate based on.
Age, weight, height, sex.
And it's, well,
I think
Age
you run
rate.
into legitimate equal housing opportunity issues if you turn someone down because they meet all your criteria and you still turn them down for someone who's better. I'm pretty sure you do.
If you like said, like, I don't want to argue this from but if I said, look, I'm gonna be soliciting offers for the next 7 days, and then my loan committee, if you will, right?
I think you're
to
gonna get
review the
in trouble doing
applications,
that.
right?
I think you're gonna get in huge trouble doing that.
Guys, first come, first serve, I mean,
Yeah.
if the first applicant meets your criteria, you would have.
Yeah, I mean, equal housing, look up the Equal Housing Opportunity
I was just
Act.
curious, if
That's,
the fee was the factor.
Well,
that's for the state of Minnesota, but
For the
not
state
for
of
the
Minnesota.
federal government. Yeah.
you can get into Fair Housing Act trouble for rejecting people for reasons that are protected by the Fair Housing Act.
Yeah.
You are able to reject people. I can reject someone from coming to rent my apartment because I just decide that I don't want to rent the apartment to them. I don't like them, and they rub me the wrong way. As long as I am not discriminating against them based on a protected class, then you're not going to run
That's
foul of the
different than
FHA.
pitting two people against each other, both that qualify. That's a different, you're actually, that's a different situation.
Well, so
If
you're
you say
talking
like,
about-
I won't rent you because you smoke, that's totally cool. But if you
Correct.
say, if you got two people, they both meet the same criteria, one's got 50 points higher
Okay.
credit score, but they both meet the criteria. This guy
Point taken.
applied first and this guy applied second. I think you just broke the law, federal law.
It's an interesting question though, whether you're discriminating against them because of a reason that, so for instance, you have two people that both meet your criteria, one of them's a smoker and one of them's not a smoker. I can reject the smoker
Yeah.
because it's a valid reason for rejecting them. What I'm telling you is that I can come up with a reason for rejecting someone that doesn't run afoul of the FHA. Just because two people submitted their applications at the same time, or one submitted one and another submitted one immediately after, doesn't mean that I have to accept the first one unless, I just can't I can't accept money and screen a person and then accept money from another person and screen that person. I have to reject the first person before I screen the second person. So that's baseline what we're talking about here, is that I can't accept fees from more than one person when I'm doing my screening. However, if I have two people who come to me at the same time, so for instance, I'm showing an apartment on a Sunday, and a group of people come and they look at the apartment and they say, I'm really interested in it.
Yeah.
And I say, that's great. Another group of people come and say, I'm really interested in it. I say, that's great. And I can't take a fee from the first one, take a fee from the second one, do that. I can screen if I'm paying to screen people myself, and I screen people, I don't have to rent to the people that came through the door first just because they were in my house first. Does that kind of
That answers my question.
clarify a little
Yeah,
bit?
yeah, I mean, you have to have a reason not to, right?
You have to have a
If they
valid
meet your
reason not
written
to.
criteria.
If they meet your criteria and you tell them beforehand, these are the criteria that I use when I'm screening applicants, then unless I have another reason for rejecting them. But what I'm saying is that my reason for rejecting them doesn't have to be something that everyone finds acceptable, as long as it doesn't run afoul of federal guidelines.
So you can say you just had a better, you can say you just had a better feeling about.
Yeah, I
I
like-
wouldn't use the word feeling. Right? Seriously.
Yeah, I don't know.
Generally speaking, proving that there was discrimination is going to be a tough case without some sort of pattern of practice.
Yeah.
So if you have disabled, you have a consistent practice of saying, I just really like these non-disabled people more than these disabled people because of this reason or this reason or this reason, they can show that there's a pattern of discrimination. But on any case by case individual basis, I can reject an applicant because I just didn't like the feel, I didn't like the vibe of the person. Like I can say, I just don't think this is going to work out, and I found someone else that I prefer to rent to.
Yeah, and I can tell you, so back in '97, right out of grad school, I was in California, and I can only rent. And we're talking federal law here, right? I think so it still applies.
Yeah, so.
There were people lined out the door to rent places there because the cost of ownership is so high. And I was very rentable. I mean, my credit history's always been right at the top. I just out of school, and they probably had 100 applicants. I didn't pay anything. So
Right.
now I'm learning why. They called back later and said, we just found somebody we wanted to rent to. I think the reason was that it's more likely to be able to pay or something like that. It's exactly the scenario.
Yeah, or someone comes and says, you know, I'm willing to pay, if I have 2 applicants and one of them is willing to pay first month, last month of security deposit and of double the amount that I was requesting, I can rent to that person because I'm in a safer position for having that money in the bank.
But it could be that they've been at their job longer, that they earned $50 more, so that makes them more secure in your eyes.
Any of the reasons that you would normally rent to someone versus another person. Yeah.
I have a really quick question. I just want to go back on the point you wrote about if you reject for any other reason, you must refund the fee.
Yeah, so you gotta give it back to them.
So, what if you had already spent, say it's $50, that's my fee for processing applications, but part of that is I already paid it towards the company that does the credit and background check, and then I paid my assistant who does the calls, you know, just so I understand, is it basically I have to refund it and I'm just gonna eat that cost?
You're gonna eat the cost.
Okay.
Yeah.
Is that true when the applications are coming through your online portals? Because multiple people can apply to your listing.
Yeah.
And let's say 5 people apply today, and they already paid the money.
I'm not familiar how your online listing works, but if you accept payment from one person, you can't accept payment from other people for running background checks. So if you have a portal where people are submitting multiple requests to see your apartment or to rent your apartment, you should be careful with accepting money from more than one person at a time. If you take the money to run the background fee and you take the money from another person to run the background fee, you can get into trouble in Minnesota if you're taking money from more than one person at a time.
Just to piggyback on that, what I've been hearing from a lot of renters the last 6 years is people will say, I've been, paying $50 or whatever, I never know if I get the unit. They'll come and tell me as they're looking at my unit. And so I'm wanting them.
They should be getting that money back.
Okay, that's interesting because
or they should be getting a reason why they didn't meet the criteria that was given beforehand. So, I mean, if you think about this logically, the reason is if I tell someone I'm going to reject you if your credit score is below 600, and this person has a credit score below 600, and they give me $50 to run a credit check on them, I take that money, I run the credit check, they have a credit score below 600, and I reject them. And I tell them, you obviously didn't meet it. They shouldn't have given me that money in the first place, right? That's on the tenant for giving me money to run a background check when they knew that they weren't going to meet the criteria that they qualified for. If they give me the money, if I say these are my criteria and they give me the money and I run the credit check on them and I decide, you know what, this just isn't going to work out, I just don't like this, the vibe of this, or I just don't feel like renting my apartment out at this time. I change my mind and I'm taking it off the market. I have to give that money back to them because for all intents and purposes, they were giving me this money, they knew they met the criteria, they were giving me the peace of mind to run the background check, I decided not to rent to them, they should get their money back, right? Yes.
Oh, can the criteria just be on your listing, or do you need to give them a formal piece of paper that says that?
You can put it on the listing, or you can tell them beforehand. I mean, you just have to inform them.
That's
before.
enough paper trail or whatever.
If you put it on your listing, these are the criteria for renting the apartment. But we'll get into a little bit about, so this all being said, that there are, so there's a proposed ordinance right now in Minneapolis that will take basically everything off the table. So the proposed ordinance is that you cannot, I should have phrased this a little bit differently. The proposed ordinance is that these criteria can no longer be used for screening applicants. So the proposal is that felonies with exceptions, so felonies more than 5 years, misdemeanors more than 2 years, with exceptions for sex crimes, murder, arson, meth production, and a couple of other things. Basically that those cannot be a criteria for screening applicants. Credit history, scores of lower than 500, which if anyone's ever had a bad credit history, is a pretty low score. Or people with no credit history that can't be used for screening applicants. And then evictions more than 3 years can't be used for screening applicants. So essentially what they're saying is what you can screen applicants for are arsonists and people that got evicted a year ago. Are really the only two categories that you can use for screening the applicants. There's a separate discussion of an ordinance that might limit the amount that people can charge for security deposits. I said see above, but I actually meant see below because security deposits is slide 7. Right now in Minnesota, there's no limit on how much you want to put in a security deposit. Go ahead.
Is this for Hennepin County?
This is for Minneapolis, Hennepin County. It's the Minneapolis City Council that's discussing. So it wouldn't affect St. Paul, but there is a tendency for these things to spill over. So it's something to be aware of, and so essentially like, and then I talked a little bit before too about the obligation for landlords to prevent criminal activity on their properties. So there's a tension between the ability to screen, particularly for criminal convictions. I mean, credit history and evictions are to protect you. Criminal history is to protect your house and the other people that live there and who live nearby. Minneapolis has an ordinance that essentially puts landlord licenses at risk for certain actions of their tenants. So if there are certain crimes that take place on the property, everyone's kind of familiar, I think, with the standard addendum to the lease about manufacturing drugs and selling drugs and things like that. But there's other things as well, like if a tenant causes a nuisance that requires police calls within a certain period of time, or that affects a certain number of people, then they're moving away from it somewhat, but there's a presumption that the landlord needs to get the person out of the unit. And that if they don't, then the city can look into the license and can talk about revoking the license.
I know somebody that happened to. I tried to list a duplex recently, and the lady had lost her license because the tenants in the upstairs unit kept getting the police called on them. The city finally said, all right, no more license for you. Can't rent. So.
Forever or for a certain period of time?
For some certain period of time, she never got back. I'm not sure what they did.
That particular property or her individually?
Her license.
Her
they
license.
revoke her ability to get a rental license.
Yeah.
For that property or all of her?
I think all of them.
Yeah, they'll take it away from you. It's something to be aware of, just because it is. So again, let's preface all this by saying right now you can still discriminate in the classic sense of the word. You can discriminate against people for their criminal history, for their credit history, and for their rental history. And there's nothing to stop you from doing that. There's no reason not to say, I'm rejecting you because you were evicted last year. You're not going to get any trouble for saying that to someone. If something like this does go into effect, then something to think about would be, if you can no longer discriminate based on these reasons, there's no reason you can't still run a background check. You'd be like, well, why would I run a background check? Well, again, it's tricky. It's a tricky area. You would run a background check because these are things that you want to take into consideration when you're evaluating the tenant.
You still have to know if they have a felony within the last 5 years.
Yes.
You still have to know if they have a credit score below 500.
Correct.
500.
Yeah, there are still reasons that you could reject them, but if your old criteria was if you have a credit score below 550, you can and you take this applicant and their credit score is 525. That taking the totality with the rest of the interview that you did with the person, talking to them, other things that you know about the person, or just like I said, you can reject people for other reasons, but if you run a background check on them, you got to give them their feedback. It might be worth the money if you're going to get into trouble with the city if you do it for a reason that's not valid. Does that make sense? Okay. Limiting security deposits. So we'll get into that, but like I said, right now there's no limit on security deposits other than, if you say the security deposit is 3 times the rent, people are probably not going to rent from you, but there is no statutory limit on how much you can a statutory or city ordinance limit on how much you can charge. They're talking about limiting it, but whether that goes nowhere or not, I'm not sure. Advertising, again, don't put anything in ads that are gonna cause issues. So, don't say no children allowed, no pregnant women. The Section 8 can get a little bit tricky. You should avoid telling people that you just don't accept Section 8 or no Section 8 applicants need apply. You can say that the unit is not approved for Section 8. Does anyone have any Section 8 units? Does anyone here accept Section 8?
I've got a few.
You do?
Not in Minnesota.
Yeah. I've talked with people in this that have been hit or miss with it. Just from speaking to people, it doesn't seem to be really that much different from the rest of the tenants. I know that it gets a bad rap, and whether you accept Section 8 or not is really a decision for you to make. But if you aren't interested in it and you don't want to get into it, and you also just don't want to get peppered with calls from people, you can put in an ad, the house is not approved for Section 8, just to kind of preclude the phone calls that you would get. And Jordan can talk to the process for doing it. I've heard it's kind of a
You have to
pain.
get a Section 8 inspection too, so you could really not be approved for Section 8, and to be completely honest, 'cause you have to get a Section 8 inspection, you have to pass all the criteria they have, which is a little more stringent than a regular rental inspection.
Do you have to pay for that?
No, I don't believe so.
You have to pay for the repairs that are required.
That they require.
Yeah.
They're gonna find some stuff.
Yeah, they will. Always do. Always do.
And God forbid they find something that might be lead-based paint or might
Right.
be
I
asbestos
just went through that,
or any
yeah.
of those issues, because they're gonna nail you on it and say you've got to get this tested. If it is, you have to abate it, and that gets really expensive.
Really,
And
really.
then isn't there's like income or like limitations on how much you can charge or how much they can pay for the?
There's limitations on how much they can pay, but not necessarily how much they can pay some sort of premium on top of that.
Oh.
Yeah.
So there's a limitation on how much they'll pay.
Right.
Joey might know better.
Yeah, public housing has a limit on what they'll pay, but in some cases, and I haven't been able to figure out the rhyme or reason, the tenant can pay more than what public housing allows.
When I called public housing, they did not know that. They told me
That they can top it off.
I don't know. I haven't been able to figure it out, so.
And it's pretty high, I mean, it's competitive rent, and they track market rents. So 3 bedrooms in Minneapolis right now are $1,650. So in most neighborhoods, that's fairly high.
Yeah, that's pretty
Let's say
good.
uptown or
Especially low
northeast.
end,
Yeah,
low end neighborhoods.
exactly.
Yeah.
Low end neighborhoods, it's
Sure.
much higher than the market rate might be.
And I think in
Because they
St.
track-
Paul, you can increase that 3% every year.
Oh, yeah, Minneapolis is that too.
Yeah.
So it's competitive.
Again, not my area of knowledge at all. So this is something that I have dealt with in the past, and that most landlords that I've talked to have dealt with. So security deposits, so you can use the security deposit for missed rent, the tenant cannot. So if a tenant comes to you and says, hey, I'm $500 short, can you just take it out of my security deposit? If you want to, you can go ahead and do that, but I don't know why you would. But it's up to you how the security deposit is there for a very specific reason. If they do miss rent or skip out or something, you can use it for rent under the law, but they can't tell you to use it for rent, and they can't direct you how to spend that money. 1% per year. People miss this all the time. I know all kinds of people that have never done this, that have owned properties for years and have never given people interest on their security deposits.
Is that just simple interest? Not
Yeah, it's
interest?
simple interest. It's just 10% of what they gave you at the end of the year. It starts at the beginning of the month after they gave you the security deposit. So you just type it into a calculator. You know what you're going to owe them. Most of the time, it doesn't become an issue because there's usually 1 or 2 things that need to be fixed. I don't know how many of you typically refund the full security deposit. I never have, because there's always been things that are broken. But yeah, it has to be returned at the end of the year with 1%. Again, these are all things that don't really matter until they do. So if you've been doing it for years and not gotten into any trouble, you don't have to go find your old tenants and give them their $10 to make up the difference. But just going forward, it's just to cover yourself. It's safe to give them 1% back if you're refunding the full security deposit.
And there's a time limit that you have to have it back to them by, right?
21 days.
21.
Yeah. End of a lease, you have 21 days to get it back to them. If you don't, then you can be liable for, I think it's 150%. I think, I've got it in here. I think I got it in here. I don't know, I just know off the top of my head. Keeping it in a separate account is preferable, but not necessary. You can commingle it. There's no rules about, keeping a separate account for your security deposits. Something you might want to consider if you are doing LLCs. Yeah, go ahead.
So it's 1%. I've seen leases say 3%.
It used to be 3%, but it phased out to 1%. So it could just be an old copy of a lease that says 3%.
Leases, I've seen some with 3, I've seen some with 1, I've seen some with no percentage referenced.
You should know under the statute in Minnesota, it's 1%.
It's 1 currently.
Yeah. But yeah, it used to be 3% until 2003 or 2005. I can't remember which one it was. And then they phased it out after that. So a couple of things that can get you into trouble if you do get into a dispute over a security deposit. So again, you can use it to pay amounts owed under the lease, but it's generally used to fix damage, and I put up there beyond ordinary wear and tear. That's in the statute, and it's intentionally vague and subjective. So just to protect yourself, and I assume everybody does this, but just in case, make sure you've done a walkthrough when they moved in, and make sure you do a walkthrough when they move out. Go through the checklist. Again, if you use the standard lease, it's got a checklist on there of the things that you should go through and look at. But one thing that people get confused about a lot is that damaged assets need to be replaced at their depreciated value. So, for instance, if I own a house and I've got a room with 10-year-old carpet in it, and I've had 5 renters, so I've had 5 people come and go. They've all used the carpet. It's been walked on, and dogs have pooped on it, and cats have peed on it. It's not the greatest carpet in the world. And my last tenant comes in and they burn a hole in it, right? And they're moving out, and I say, well, I have to replace this carpet, and it's going to cost me $1,000 to put new carpet in. I don't get to charge that tenant $1,000. I get to charge them what 10-year-old carpet that's been pooped on and walked on and lived on for 5 years costs.
$900.
$900. So, basically the security deposit is not just a license, a blank check to use to renovate your house at the end of a tenancy. They are obligated to pay for the damage that they caused to the assets at the value that the assets are worth at that time. So yeah, I have seen people say, you owe me the full, I had to replace, because you have to replace the carpet, right? They burned a hole in it. You probably could have gotten a couple years out of it, and that's what it's worth, right? It's worth what carpet would be that you could get 2 more years out of before you replaced it. 21 days. So after they move out, you have 21 days, and it's actually I said 150%. It's 100% of the deposit plus the bad faith penalty. So if you don't give it back to them, if you're holding on to it, if you're trying to get something out of them, just don't mess with the security deposits. Just send it back to them within 21 days and show them with receipts how much you paid for stuff that you fixed. Yes.
What about damage that exceeds the amount of security deposit?
And then you got a small claim.
Okay.
Yeah, and we'll get into that a little bit. Has anyone here been to conciliation court?
One time.
Yeah. How was the experience?
Easy. I mean, they were wrong. You know what I mean?
Sure.
So it was a piece of cake.
And did they pay you?
But no, eventually, but it took like 8 or 9 years.
Yeah.
I mean, I just got paid very recently.
Cold comfort.
Yeah, and nobody else has been.
And I got
same experience?
Well, very rare that they show up.
Yes. Oh yeah, you have 1,300 people. Yeah. Generally speaking, and we'll get into this a little bit when we talk about eviction, because eviction becomes a real balancing test for landlords. There's a time cost. There's a lost income, and you really got to know when to cut your losses. And it's hard for people because you get really emotionally invested in these things, and you just really hate these people, and you want to just give it to them, but you have to realize at a certain point that you're just kicking yourself. A lot of times you're dealing with people that just don't care anymore, and you got to know when you're just gonna say
done is good.
"Hell with it." Similar to conciliation court. Conciliation court is a way to make yourself feel better, but to get your money back, it's really not that great. But we can talk a little bit about it. And again, if you've ever been to it, it's a nightmare. I've been once myself, and I didn't get paid. So. Obvious stuff, give them a copy of the lease, make sure you keep a copy. You'd be amazed how many times people come and they say, I need to evict this person. I say, where's the lease? The signed copy of the lease. And they say, oh, have a signed copy of your lease, keep it in a safe place, know where it is, know what the terms are, so that, when you say, you violated this clause of the lease, you can say, you signed it here, you initialed it here, you knew that this was an issue. Standard lease is on that site, they're all over the place, you can find it. Go ahead.
So for people who do a house hack, is room lease agreement or as legally binding as a lease for a whole unit?
It is, and in fact, oral leases are valid. I mean, it's not a matter of whether the lease is enforceable or not. It's just whether it's going to be a huge pain for you to enforce it. But yeah, room leases. What was it? The other one you mentioned?
No, that's it.
Oh, okay. Yeah, they're as legally enforceable as any other lease. I mean, they're signing a contract for a piece of property for a set amount of time, and just like anything else, you can evict them.
So, like for instance, I've got someone who signed a month-to-month, and one of the terms of that agreement is a 60-day notice prior to moving out, and they're opting for shorter notice than that, which would then essentially disqualify them from having their deposit returned, correct? Because of if there's not.
I'm going to give you the standard legal. It depends. If they owe you money, then yes, they will forfeit their security deposit. You can use that for the rent that they owe you, and they're not entitled to get that back.
Couldn't you argue that they owed you money for the 2 months then?
Yeah, and that's another thing that we'll talk about with breaking leases early. So in my span as a landlord, I've had 8 tenants, and we had 2 that tried to break their leases early. So I've got about a 25% rate. I don't know if that's standard, but I imagine people have seen it before. And we'll talk a little bit about ways to deal with it. But I talked about this, that unconscionable clauses likely won't be enforced. You can put anything you want in a lease, but when you get to a judge, whether they're going to actually enforce it is, and this is the thing to understand too about housing court is it's kind of a wild west. There's not a lot of rules of evidence. There aren't a lot of procedural protections. It's just kind of a free for all, and the judge can do pretty much what they want, and no court's going to look at it. Yeah.
Can the judge basically throw out your entire lease if you write something in there?
No, they won't throw it out. They just won't enforce the clause. Yeah, I mean that's just standard. That's just standard contract interpretation. They'll excise the clause that is unconscionable, and they'll leave the rest in place. Unless your entire lease is just insane. Yeah.
I had a really quick one about something you mentioned previously, and it was the risk of using your rental license due to allowing illegal activity be conducted on the property.
Yes.
Do they need to prove that you were aware and allowed it?
Yeah, I mean, so there, it can't. It's, and I guess I should have gotten into this a little bit. So, so we have a tenant who calls us. She's finally leaving, thank God, next week. And since she's been in our place 18 months, we gave her a 1.5 year lease. And so since she's been there, she's probably called once a week to tell us, oh, it smells like pot, they're fighting, this is happening, just constant complaining. Never called the police. I don't think there was ever any reason for her to call the police. Nothing ever arose to the point where the police would be called. That's when you're going to get into trouble. So if the police have come out to your place on a number of occasions, you'll know if the police have come to your place.
How will you know?
Well, that's a good question.
Because you don't actually. I have a property in St. Paul,
and they didn't notify you.
And one of the tenants said, this is going on. What do you want me to do? The cops have been here a couple times. I had no idea.
Okay, well that's an interesting point though. Yes, you have to have notice that it's occurring. They are not going to take your rental license if you had no idea that anything was going on at the property. Okay. And if there's no record of anyone telling you that the police have been called, or there's no police report that was filed that you're aware of, then they're not going to come out to your license.
But it has to be like a police report, not just like hearsay from the neighborhood,
No,
like,
not
oh,
just this
they're
guy's
no
up to
good
no,
over there.
yeah, they're up to no good, they're not doing things on the up and up, yeah.
As part of the tenant covenant, so isn't it state law that you can get someone out if they do break certain laws? Like, for example,
Absolutely.
I know drug is one of them, but that means that's that's something you can use to terminate a lease and.
Absolutely, and you can use the fact that the police have been called out on a number of occasions and that they're disturbing other tenants as a grounds for breaking someone as well.
And is that in the standard lease, that if
The crime-free addendum is, and it covers certain stuff, but what we're talking a little bit more about is like the nuisance stuff. So, you want to avoid, and again, like taking a person's license is a pretty drastic step. They're not just doing it willy-nilly because, you know, you got someone called for a noise complaint and you knew about it, you didn't do anything. It's generally for chronic problems. So a place where the police have been out 4 times and you're just like, I can't control my tenants, then they might look at coming after your license. And yes, there was a tendency in Minneapolis to just err on the side of axe them, you know, get them out. If there's any criminal activity, just get them out of your apartment. And, you know, you may be safe doing that. You know, use your judgment on it. But again, generally people know when you're ignoring a big problem and you're getting complaints and it's become an issue, then you might want to consider evicting the person just to protect yourself. Yeah.
I'm sorry.
No, go ahead.
Oh, I was just wondering, so like with that nuisance clause, so like say that happened where you find out, oh, there's some, you know, there's this stuff going on multiple times and you didn't know, can you, with the nuisance clause, is that like, you have to give them multiple warnings or can you just terminate the lease?
If they meet the criteria, I don't have it in front of me, and it's pretty dense. But there are pretty specific, like, you know, it states in the ordinance, you know, if a, and I'm speaking from memory here, so I'm probably misquoting, but it's things like, you know, if a nuisance happens twice in 30 days that affects 1 unit of the premises, then you can be held responsible. Or if it affects more than one of the surrounding neighbors and happens twice in 60 days. It's like very specific criteria for what qualifies for running afoul of the ordinance.
Okay.
It's not something that you have to be familiar with unless you think it's going to be an issue. So if you're getting police calls about a unit, if you find out that there's criminal activity happening in a unit, you should definitely take steps to protect yourself so you don't risk it.
So if you hire a management company, you don't want to do any of this, you hire somebody, pay them 10%, how much are you insulated from this? How much comes back on you with this problem?
I actually don't know the answer to that question. I don't know how much of it would depend, I think, on the management contract.
There's some people here, man.
Yeah, does anyone know? Everyone looks at the property manager.
As far as I know, and disclaimer, I manage for large multi-family apartment buildings, not small
Right.
operations. But as far as I know, the owner is ultimately held responsible. You can probably then turn around and sue the property management company, but I think as the owner, you can pretty much expect the ultimate responsibility.
I mean, you know, how hands-off you are on your properties. There's a minimal presumed amount of awareness that you know what's going on the properties and that you're kind of keeping tabs on things. It's not really going to be a defense in court, or I say court, but if you go before a magistrate judge and your license is at issue, and you say, well, I was in Florida and I trusted this guy to take care of it, you know, if you look at it from the judge's perspective, his thought is, well, we don't want landlords like this, right? We don't want people that are just willy-nilly, you know, renting things out to criminals and letting stuff go down and things happen. It's really not something, it does come up and it does happen to people. It's more of just a cautionary issue that you should try to be aware of what's going on in your properties to the extent that you're able. I mean, you know, cops can get called and nobody says a word, and that's not your responsibility unless you become aware of it. Once you are aware of it, then it does become your responsibility. So if you know of things that are happening on your property, you should know that it is something that you have to deal with. You can't just, you know, wipe your hands and say, tenants are going to do what tenants are going to do. And as far as, yeah, like unconscionable clauses and things, if you stick to the standards, you're probably not gonna get into any trouble. We talked a little about early termination. You can agree to break a lease whenever you want. If the parties come together and you say, we wanna end this lease next month and we're happy to part ways, then that's totally fine. You can put early termination fees. Some leases will have an early termination clause that says, you know, if you break this lease before the end of the term, you're responsible for 2 months worth of rent or some set fee. And there's generally like standard language that you'll see that says, you know, in order to avoid the cost of reletting and cover the time and effort that goes into finding another person for the apartment, you could put them in there, but you have to be careful about double collecting. So you can't put an early termination fee in there. I shouldn't say that. You can put an early termination fee in there, but you can't collect a out of proportion fee. So you can't say, essentially, the early termination fee is $5,000 up front that you have to pay if you just move out of the apartment, and then immediately rent it out to someone else and keep the $5,000. I mean, you can, but that the tenant can sue you and come after you and try to collect that back and say, he mitigated his damages. Under the terms of the lease, the purpose of the security fee or the purpose of the early termination fee is to compensate them for the lost income after I moved out. He rented it the next week. A judge is going to give them back that money. So, and again, this is a bit of a judgment call, but generally speaking, you can put an early termination fee for what you think it's going to cost for you to re-rent the apartment, plus some time and effort. And again, the issue with it.
Is it important to have it in writing ahead of time, or could you, if someone contacts you, could you almost make it up, like, for example,
like
it's easier.
An addendum to the lease, you mean, or?
No, I mean just like not have an early termination fee, but if they contact you and say they want to break the lease, then you go, well, it's June, here's what I'll do.
Exactly.
Or it's December, here's what I'll do.
So what I was gonna say is it's probably better to. A lot of people love to put these into leases, and it does give you some leverage when you're negotiating with the client, or if the tenant who comes to you and says, I want to break the lease early, and you say, well, then you're going to owe me this. And it gives you some hard numbers that you can say, this is what you owe for the early termination. One important thing to know about Minnesota, and I don't know if people know this or not, but there's no duty to mitigate. So if a person leaves your apartment, you don't have any duty to re-rent that apartment. You can sit on it until the end of the lease, and they owe you the full amount. You can't, like I said, you can't re-rent it and then sue them for the full amount. If you mitigate your damages, then you've mitigated your damages, and they're only liable for the portion of damages that you actually have. But you don't have any duty to do it. So that's your fulcrum for negotiating with them if they want to leave early. You say, okay, you want to leave early. You still owe me, you're still on the hook for 3 months of lease. How about you give me? I think it'll take me 3 weeks to find someone for this place. Give me that amount prorated, and we'll call it a day. If you do that, get it in writing. Write out a contract that says, I'm agreeing to end the lease on a specific day. That's the day that they're going to move out. It's basically an addendum to the lease, so that if they don't leave, you can go to housing court and evict them and get them out.
What's the practical reality of collecting these fees?
The early termination fee?
Yeah.
Slim to none.
Yeah.
And that's why I say, like, people love to put it in there because it makes you feel good. It makes you feel like if they leave, you're going to give it to them.
Yeah.
Actually collecting the fee, no.
Yeah.
It's like I said, it's generally speaking a leverage for negotiating with them when you want them to do it. But if you have to pay it.
Yeah, I mean, we had 42 tenants last year total.
Yeah.
And out of that, 3 of them tried to get out of their lease. And I used 2 months. And all 3 of them just stayed in their lease to the end.
Mm-hmm.
Right.
They're just like, oh, okay.
Yeah,
and so another thing it does is just puts it in perspective.
So yeah, I was curious about if they do actually just say, well, no, screw it. And
Yeah,
leave anyways.
If they
it's
just
going to be
leave,
hard to.
then you have a contract that says they owe you this amount of money. You can go after them for it, but again, that puts it right back in conciliation.
Yeah. Okay.
If they've just left and abandoned it, what prevents them from coming back 3 months later and say, oh, well, here's the money and I wanna move back in?
Because you have to evict them.
Okay, you do have to then go and evict
Yep.
if they just
Yep.
decamp, okay.
Absolutely.
So say you signed the lease yesterday with your new tenants who are, this lease was starting tomorrow.
Uh-huh.
And today they contact you and tell you that they no longer want to be a part of this lease.
And they've signed it?
They signed it, dated yesterday, the lease starts tomorrow. They call you today, or text you today, and tell you that they no longer want to be a part of this lease. We also, in this scenario, have a check for $2,900 or something that was the partial first month's rent and security deposit.
Right. Not to give you legal advice, but from a very
Yes, in this possible scenario.
Theoretically speaking.
Hypothetically. I'm asking for a friend.
Yeah. So here's the thing. It helps sometimes. Everyone's familiar with leases. Nobody thinks about leases as an actual contract. Tenants don't think of them as contracts. Nobody thinks of them as contracts. Tenants think that when they pay you rent, they're like doing you some kind of favor, and they're really helping you out by giving you this money, and you should be grateful for it, even if it's 2 weeks late. And don't you know how hard they worked for this, et cetera, et cetera. You've got a contract, right? So just think of it as, I signed a contract to give you my car. You didn't give me the car, or I signed a contract. I gave you money. You were going to give me a car, and you don't do it. Then you go to enforce the contract. If someone signs a lease and they, there's no difference in the law if a person is on the first day of their lease versus the 363rd day of their lease. It's just the amount that they're going to owe that's going to differ. And so if someone says, I'm going to move in, because think about the damages here, right? Like someone says, I'm going to move into your apartment on June 1st. I all of a sudden push all these other applicants out. I don't take any more applications. I get the apartment ready for them to rent. I get everything ready for them to move in. They don't move in. I'm out a month's rent at least. I mean, I'm not going to, if you can find someone to move in on the 15th, great. But like generally speaking, you're probably going to be talking about the next month. So that's your damage, right? Whenever you can get someone else in. Unfortunately, if a person does that, you're better off negotiating with them to try to work out a compromise for it. To say, we have damages here. We don't want to evict you because they have a right to claim the apartment, right? You have an obligation under the contract. They have an obligation under the contract. So if you keep their money, they have a claim on that property, right? They have a right to be there. And if you are going to rent it to someone else, you need to get rid of them first. So you have to evict them before you can put somebody else in place.
Or have them sign something.
Or have them sign something that says, I'm really, the contract is void, I'm moving out on this date or whatever, and I'm gonna pay this amount of money in order to get out of the lease. But it's the same as any other early termination. It's just happening on the first day of the lease.
If you have them sign an agreement that they'll pay 2 months rent to get out of the year lease, and then you end up renting out 1 month later, are you still on the hook for double collecting after mitigating your damages?
So in that type of situation, I mean, yes and no. It's sort of the reverse situation, right? So if they sued you and took you to court and you went in and you said, they said, I paid him this amount of money, he only has this amount of damages, I'm entitled to that money back. There's a good chance, who knows what's gonna happen in court, but there's a good chance that the judge would say, you're right, you owe them that money. Is it possible that you could say, I had this clause in my lease, they owe me this amount of money, I happened to find someone, but it easily could have taken me 3 months, and then I would have lost money on this situation. There's an argument to be made, so there's not like a clear cut, yes, you're screwed if you keep it. I'm generally of the, and I don't know if this is normal or not normal for a lawyer, but I'm generally of the working it out is always better with parties, and especially in these types of situations.
Your first loss is your best loss.
If you can avoid getting to the point where you're in front of a judge, then that's probably in everyone's best interest. So I actually work with sober houses sometimes, and it's a little bit different because it's not a traditional renter's agreement. They sign a contract to live there. Jordan's familiar with this too. But whenever somebody gets kicked out, they always come back and they say, well, you owe me this, and I'm entitled to this, and you had no right to kick me out of this house, and I'm gonna take you to court. And I have the sober houses come to me and they say, well, what should we do? Do we owe them this money? And I say, no, you don't owe them this money. You don't have to give them anything. But if they sue you, then you're gonna have to go to court. You have to do this, you have to do that. Is it worth it for you to give them $400 to make them go away? Probably. And so it's the same type of situation with a renter. If they gave you that check, they said, I want out of this lease and I'm gonna give you $3,000 to do it. Part ways, don't ever talk to them. You know, how do they know you rented the apartment out? 2 weeks later, they have no idea what's going on. But if they do come to you and they say, hey, I see somebody's living in that apartment, I gave you too much worth of rent, I'm gonna take your ass to court, it might be worth your while to say, okay, I'll give you $1,000 back. But technically speaking, no, you don't, I mean, you don't ever have to give anything back until a judge says you do. Limited circumstances.
Just, how much do text exchanges or email exchanges count in terms of arriving at written proof that you've arrived at an agreement?
More than they used to. Email's generally better. Text exchanges are a little, judges kind of a little funny. Okay. Email's just fine. Okay. If you've got an email exchange and it's got all of the identifying information on it, you're not going to get into a case where, like I said, my day job is doing electronic discovery. You're not going to get into a housing court that just can see, I need to see a forensic accounting of where this email came from. Like if you have printouts of the email and it's clearly got your address and their address.
Okay.
It's fine.
Yeah, I actually encourage my tenants to communicate via email now. Just because then it's, hey, email me. If you have to call me, but please email me and then we can arrange after that.
Okay.
All emails.
So a little bit about lease termination. Most people know this, some people don't. If you have a lease, it automatically, if a lease ends without you renewing, it automatically converts to tenancy at will under the whatever the terms of the previous lease were. So if it's monthly rent, it converts to a month-by-month tenancy. I put this in here just so you should know that if you do have a month-by-month or a tenancy at will, that there are different requirements for eviction notice. If you do need to get rid of someone, you have to give them 14 days notice after they've paid their rent late. And notice requirements in the lease, this is about terminating. Generally, there's a 30 or a 60 day, just make sure you meet it, or they meet it, and that if it's a tenancy bill, you gotta give them a rental period plus 1 day. Oh, and also that the notice for leases is when they receive it, so you can't mail it on the 60th day, or 60 days before mail it to them, that would be valid. It has to actually be in their hands 60 days before the lease ends. Couple things about rent. Just to protect yourself, if you're accepting cash, make sure you give them a receipt. That if you have multiple tenants, they should know and you should know that they're all jointly responsible. So if one of them doesn't pay, it's no excuse for them to say like, oh, well, Joe didn't have his $300 this month. Like, they're responsible for making up that difference, and you can go after them for it if they miss it. Late fees are 8% of the overdue amount. So where that generally comes into play, this is part of the standard lease. It can't be more than 8%. You can take less if you want. But it comes into play with partial payment. So if I have a late fee, an 8% late fee clause in my lease, I have a $1,000 a month lease. So it's $80 for a late fee. If they pay me $500, I can only accept 40, or I can only charge them 40 for a late fee. Right? So it's whatever's overdue, 8% of that can be a late fee, nothing more than that. So I can't accept $500 and then charge them $80 a month for a late fee.
So can you just not accept partial payments?
You can and charge them the full 80 amount and say, come to me and you've got the full rent. You don't ever have to take partial payment. So be careful with partial payments. It affects late fees and it can create eviction issues. So yeah, go ahead. Oh, it can create eviction issues. So it can toll the amount of time that you have before you can file for eviction, and it can make what is already a terrible procedure into an even worse one. So generally, what most people want to talk to me about, or when they see me, is when they need to get rid of a tenant. So like I said, I've evicted one tenant, gone through a partial with another tenant, and I've done evictions for maybe a half dozen people. a couple of things about eviction. Like I said at the beginning, it's an emotional process for landlords. You get really tied up into it, and you really want to like do something to these people. So the first thing I tell people when they come to me and they've got an eviction situation is to, you know, first of all, tone it down. So a couple of things that you cannot do and you need to really avoid doing. You can't lock them out. You can't change the locks.
It's just in Minnesota too, right? Different states you can.
Some states will allow, shutting off utilities is generally a no-no in most places. Changing like, Minnesota, yes, Minnesota is much more tenant-friendly than other jurisdictions. There are other places where the penalties are lower. It's much easier to get rid of people. You can change locks in some places. I'm not familiar with the laws in them so much.
I know in Texas you can lock them out for late rent until they pay the rent.
You don't have to let them back in.
You don't have to let them back in.
So, I don't know if Texas.
I like Texas.
I think in Texas you can meet them with a crow.
We're talking Minnesota purely here. So Minnesota is a very tenant-friendly state. You can't shut off their utilities. You can't harass them. And harassing is like, you know, multiple repeated calls. You can call them and ask them, hey, are you going to pay your rent? But don't get excessive with it. You know, don't start like just robo-dialing them. Don't call them at their office, call their mom's house, call everything else. Like, you know, it's pretty clear when someone's avoiding you and not paying the rent. So if use your judgment. If you're calling them because you just want to be a pain in the ass, you probably shouldn't do it. If you actually have legitimate questions and you want to find out what's going on, then that's fine. If you do unlawfully exclude someone, so if you get into court and they charge you with unlawful exclusion, it's a pretty stiff penalty. So whatever their damages are, which is going to be a subjective deal, 3 times that plus fines. One thing that I've seen a lot of landlords miss, and this is from both the evictions that I've done and just people that have come and talked to me. So a lot of times people come talk to me and I say, okay, so let me start this off by saying eviction is a process that any of you can do. There's nothing in, people are sometimes like scared of eviction and they worry about like, you know, I'm gonna screw things up. You can handle it yourself. It's not rocket science. Housing court is a pretty, like I said, it's a pretty like free-for-all place. Like, you know, you get your paperwork, you file it correctly, you go before the judge, you tell them what's going on, you get out. Most of the times when people hire an attorney, it's because they just don't want to be bothered with it. They have a job where they can't take off 3 hours to go down to housing court and, you know, and sit there while people do the craziest stuff that you'll ever see in housing court. Generally speaking, you know, you hire an attorney when it's like, I don't have the time to deal with this. I need somebody to just take care of this for me, and I know it's going to be done right, and they're going to be out in a certain period of time, and I don't have to do anything with it. If you have the time and you have the inclination, it's something that you can definitely do. And there's just a few kind of pitfalls to avoid. The most common one being, so one thing that people miss is if they don't have their rental license out. You have to have it displayed in the house in a conspicuous place. It has to list who owns the property, who manages the property, and the person that can accept service on the property. If that's not displayed, if you don't have proof that it was displayed, so put it up, take a picture of it. You're going to get into court and they're going to throw it out. They're going to say, come back in 30 days after you've been displayed the license.
I had an attorney tell me that the lease, when the information is listed in the lease, that was acceptable.
Still has to be displayed. Yeah, it does. It has to be physically displayed at the property in a conspicuous place. Yeah, I mean,
I know what it is.
it's the same kind of thing. Like if you get in there and you're in an argument and you say, listen, I mean, because the purpose of the statute is so that they know who to contact. If, you know, I'm suing you, you're suing me, I know who to serve process on, I know who can accept process. If you can show that they knew that, so that's the thing. I mean, the step is they say, well, he didn't display it at the house. The statute says he has to display it at the house. There's a clause underneath that that says if they had, you know, basically constructive knowledge of it and they knew beforehand who could accept process, then you can do it. It's just best not to get into it.
Got it. Okay.
So the second thing is make sure that the house is habitable. It sounds kind of obvious, but until recently, habitability wasn't a defense in eviction actions, and then a couple of years ago, the Supreme Court decided that it was. It used to be that if a tenant wanted to claim that an apartment or a building wasn't habitable, they had to file a rent escrow action. So they had to go to court, they had to pay the rent into escrow, they had to say, these are the things that need to be fixed, these are the times that I asked for them, he hasn't responded in this period of time, here's the inspection report. You'd have a hearing on it, the whole 9 yards, right? The Supreme Court last year, the year before, decided that they can now raise that as a defense in an eviction action. So, you get to your eviction, you think everything's great, the tenant gets up there and says, I can't live in this house, and I withheld my rent because it's a shithole and rats everywhere. So be prepared for it, because especially if they talk to legal aid, which sometimes these tenants will do, they're gonna bring it up. So the basic reasons for eviction, the number one, of course, non-payment of rent. They just haven't paid their rent and I'm getting rid of them. Breaking lease terms, criminal activities, which we talked about, excuse me, and a refusal to leave after a notice to vacate. So that's the end of the lease, or on a tenancy at will after you give them 14 days after they haven't paid. So again, the most common non-payment of rent, you can evict the day after rent's due. So it's due on the 1st, you don't have to charge them a late fee, you don't have to give them 5 days unless you put it in your lease. So if you say, the tenant has until this day to pay their rent, then that's the day that you can evict them. But basically, after they breach the terms of the lease and they haven't paid you their rent, you can take them to court. You don't have to talk with them, you don't have to do anything, you don't have to try to work it out, you don't have to see where they're at, you can just go. And you may want to do that to avoid problems. I've seen it go both ways. So in my own situation, like I'm as hesitant to pull that trigger as anybody, and even with the past history where it's like I just don't, maybe they'll come through, and is it really worth doing this? We'll talk a little bit about the timeline for it and how long it takes to actually get somebody out, and when you might want to consider doing that, because it does come into play. I don't want to run out of time, so this is the process, and I put up here days to kind of get a sense of how long it's going to take for you when you do this process. So basically, yeah, go ahead.
Don't mean to be intrusive, but could you hit the display button in the lower left corner of the PowerPoint so it's full screen?
Oh, of course. I didn't know how to do it. This one? Oh, that's spell check.
Others.
This one.
The one that looks like a screen just to the left of the slider on the, go to the right side.
Right side.
Lower, it looks like a little movie screen, right?
And then the divider, you can also go to slideshow at the top and click
Oh, yeah.
AV Club.
That's the only way I know how to do it.
Okay.
Oh, slideshow.
And then it'll say from current slide is the option. Go ahead and click
There's a
that.
tiny little screen on it.
No, that doesn't work.
Right next to the slide.
Oh.
There you go. And from current, there you go.
There you go.
Right.
Did it work?
Ta-da!
Yay! Is that better?
Yeah.
Perfect.
It just makes it bigger.
Oh, this is amazing. All right. You can tell I've done a lot of PowerPoints in my time. I have never done a PowerPoint before. So day one, tenants like paying rent. It's clear that they're not going to pay rent, and I'm going to take them to court. So what you're going to do is you're going to head down to the court. You can actually do this electronically even. So if you file for sign up for an Odyssey account, it's minnesota.tylerhost.net. You can do this electronically. You need to have a copy of the lease, full name and date of birth of each tenant, which should be present on there, and $325. The court's going to give you a summons. They're going to set a court date 7 to 14 days out from the day that you go and file your complaint. So you'll get a piece of paper that says summons on it. Attach the complaint to the summons. So I should just preface this by saying the most common reasons that people's eviction complaints get thrown out is because of insufficient process. So they didn't serve the person correctly. You get to housing court. It's the easiest thing for the judge to do. The judge looks at it, he says insufficient process, boom, it's gone. You just lost $325 and you got to start over from scratch. So attach the complaint to the summons and serve it on them at least 7 days before the court date. Try to take care of it right away if you're doing this. You want to serve them in person if you can. if you wanna hire a service, process server, it's generally like $75.
You can hire anybody to do that.
Yes, you can. It can be
I'll
anybody
do
but
that.
you. Sure, they'll do it for $75.
$50.
They have to find them, they have to serve them, and you have to serve it on every person that's on the lease. But yeah, it can be, when we did it, it was my wife's sister, and she did it incorrectly. And so we got to court, and I was out $325. I didn't know she had done it incorrectly. I explained to her exactly how to do it. I should have hired a service process. What she did is that she forgot to grab the bottom page of the complaint. The page with our signatures on it has nothing of any substance on it. She gave them the summons, she gave them the complaint. She came back down, and I said, "What's this?" She said, "Oh, that's that signature page." And I said, "Why didn't you think it? I didn't think it was important." She said, "It's very important." I said, "Go back upstairs," because they lived right above us. I said, "Go back upstairs, give them this piece of paper." They wouldn't open the door. Wouldn't answer it. They wouldn't even acknowledge that she was there.
You can't just slide it under.
You can't just slide it under the door. You have to physically hand them the piece of paper.
Who proves what?
We slid it under the door. We tried to serve them by mail by saying they wouldn't answer their door, and there's a separate process for service by mail. Needless to say, it was not sufficient. We got to court, they threw it out. I had to start over, and they got to stay in the apartment for another 2.5 weeks. So, yeah, don't screw this up. Physically hand them the papers, make sure that all the pages of the complaint are with it, make sure that the summons is with it. If you can't locate them, or if they won't accept, there are certain procedures to follow for mail service. And this is where sometimes it's helpful to have an attorney, because this can get kind of complicated at how you serve someone with mail. You need to make sure that you can demonstrate that you tried to serve them twice between the hours of 10 and 6 on non-consecutive days. And there's another requirement for service by mail that has to be met. You have to post it. You have to post it in a conspicuous place on the property for a certain period of time. Generally speaking, if you try to serve them, service by mail just does not work well in eviction actions because of the time requirement to serve someone by mail, plus the requirement that they've served 7 days before the court date, plus the requirement that the court's gonna set 7 to 14 days out. Yeah.
What proves that you did serve to them if they just said, we never got it?
You get an affidavit from your service process.
No, like if you served it yourself.
You can't serve it yourself.
Oh, you can't, okay.
No. That's statute. Someone other than you has to serve the process on them. You haven't signed an affidavit. So
someone without interest even, right? So it can't be your spouse either.
No,
like,
it can't be your spouse. Someone
it can't be with no interest.
Person serving as an active.
But it can be your spouse's sister who's
What if they don't sign?
Julia. So you give them paperwork, they serve it on them in person, and then they fill out an affidavit. That's valid. If they come and they say I wasn't served, you say here's the affidavit. So if generally that works fine. If you can find them, if you know where they are, just wait for them. You see it on TV all the time, like you've been served. But if you can't locate them, it might be worth your while to call somebody because you got to move quickly and you got to get it taken care of. So mail service, like I said, there's some requirements. You got to post it. You got to do some other things. You can also, if you can't locate them anywhere, you can leave a copy with a person of suitable age and discretion. So you can't give it to their 5-year-old kid. There's a person at the property when you go there who is of suitable age and discretion. And when I say you serve every tenant, if you serve a person at the property with 4 copies of the summons and complaint, you say this is for all of you. You don't have to find each one of them and serve them individually. You can serve a person at the property that has it. If you do track them down, you should track them down individually. So if you go into their offices and serving them, you should serve them all with a copy of it. So now we're looking at, generally speaking, 10 days, but it could be as many as 14 days out. Once you get in there, they can ask for a continuance of 6 days. The judge can grant it or not grant it at discretion, but now you're looking at 20 days out. So generally, we're talking about people who haven't paid their rent. If they show up and they've got the total amount due plus interest plus filing fee plus reasonable attorney fees, which can be disputed and fought about, the judge will basically take the money, give it to you, they move back into the apartment, everything goes away. If they show up with the money. But know that they have to pay that $325 that you paid to evict them. So if you want to tell them that, like, hey, I'm going to evict you tomorrow, you're going to owe me the rent plus $325 plus, other stuff. That's something to let them know. What they might say when they get in there, you served them incorrectly, is the main one. So make sure you serve them correctly. The second one that comes up most often is habitability. So it's a defense now. So basically what the tenant says is, I withheld the rent on purpose. This unit is not habitable. I can't stay in there. I need them to fix this, and that's why I didn't pay my rent. Be prepared for it. So they have to show that they told you in writing that there were repairs and that you didn't respond to it. They can't just go in and say, this place is horrible, I can't live there, and that's why I withheld my rent. They have to have some evidence to show it. But if they do have something, like, be prepared for it. So if they have sent you complaints in the past and they said, I need you to fix this, and you didn't, before you get into court, make sure it's fixed. Make sure you have a record that it's fixed, and proof that it's fixed. If the unit is not habitable, so it's a subjective question, but it's kind of somewhat obvious. If they don't have a stove that works, if they don't have heat, if they've got broken windows, if they've got a leaking roof, if there are things like that have happened in the apartment and you haven't gotten them fixed, then you should know that that is a defense to an eviction and that you're going to have to explain it to the judge. What I've seen a few times is landlords who have an issue that they're trying to fix but they just can't get it fixed. So you've got a building and you've got a leaking roof, and you pay somebody to come out and they look at it and they say, okay, this is what's wrong and it's going to take me this long to fix it. I'll do a patch in the meantime, and we're going to arrange for this. It's the middle of the winter, we can't do roofing work, et cetera, right? Meanwhile, there's water leaking into the tenant's apartment, and they're saying, I'm going to withhold rent if you don't get this fixed. You're kind of in a bind at that point. And what you need to do is try to work something out with them. It's going to be tough to evict someone for withholding rent if they're in an apartment that has an issue that's making it very difficult to live in. So if you're in a situation where you aren't able to get it fixed, you can try to work it out with them by giving them prorated. So basically reducing their rent for the time that you're fixing it, or even refunding them the rent for the time that you're fixing it. Anything to kind of keep the relationship solid during that time so that you can hopefully move past it. But you're gonna have a tough time evicting them if you've got issues at the house that are arguably making it uninhabitable.
I have a quick question.
Yeah.
Have you had instances where there was like an eviction, but it wasn't based on unpaid rent, it was based on lease violations? I mean, I've dealt with the unpaid rent issue, but I haven't dealt with, when we have renters who are like.
So if you have a lease violation, and it's not the criminal activity lease violation, so we're talking about things like having a pet when they're not supposed to have a pet. Smoking inside, violations of the lease. You have to have evidence to show that it's happening. So you can't just say, I'm evicting them for smoking in the unit because I can smell smoke in the unit. You have to somehow have pictures of them smoking in the unit, and then you get into issues with, am I violating their privacy? Like, it's tough to evict people for lease breaches, just as a general matter.
Even with pets?
Pets is a little bit easier because you can prove that somebody has a pet in the apartment. You can say, there's dog poop in my yard, and I can see that, and that's like, I'm going to. But the thing of it is even with clear lease violations, like things with pets, housing court judges, and I know this from just talking with other lawyers that have done tons of it. Basically, Minnesota judges are hesitant to toss people out of their houses. If they're paying their rent, they're not destroying the place, they're not selling drugs. Judges are just really not disposed to tossing people out of the place. What they'll basically say is, this doesn't seem like a big enough deal to end the tenancy. You just have to tough it out until the lease is over.
What about like drunkenness or domestic issues?
Again, it would fall under that criminal umbrella.
Is drunkenness a criminal?
No, so you can't. And like I said, I work with some sober houses.
Yeah.
It's tough to get an alcoholic out of a house.
Yeah.
If they're not doing something that's actively destroying it, or they're doing something that's actively criminal,
Right.
they're just, you know, a piece of crap that's laying around hammered drunk, and there's garbage everywhere, and you know, like stuff that you would be like, I don't want this person in my house anymore.
Uh-huh.
It's tough to get them out.
And what about domestics?
If the police get called.
Yeah.
Yeah.
All right.
But just generally speaking, yeah, the breaches of the lease are tough. It's unfortunately, you may go to court and get some kind of order from the judge saying, you know, if this happens again, et cetera, but actually physically getting them out of the apartment is hard, unless there's some pretty clear violations. And clear violations of those really like kind of big, violent, important things, or they're just not paying anyway. So the reason to bring them up is that they do bolster your case when you get into court. If you've got like if you've got a non-payment of rent, you can add in, and also they had pets when they weren't supposed to. They did this, they did this. But you know, if you go, so I've seen, you know, cases in housing court where a landlord has alleged pretty clear violations of the lease, like pets is the most obvious one. You know, they've got 3 dogs in this apartment. I have a no pets clause in there, and they haven't paid their rent, right?
Mm-hmm.
They get in, the tenant shows up with the rent on that day, and they can't pay rent.
So if you say you file your eviction notice or whatever, the paperwork on day 5, and they pay rent on day 8, what happens?
They come and they give it to you?
Yeah.
I wouldn't accept it. I would go to housing court and tell them to bring it there.
I see.
I'm not going to lose that $325.
Yeah.
If you take the rent from them at that point, you don't have any damages. You don't have any grounds for eviction.
Okay, so if you go to housing court, then they owe the $325 for the filing and all that stuff. Okay.
You know, I would just tell them, you know, pay to the court, we have a date on this. Like, I'm not going to interact with you until you get into housing court. Oh, go ahead.
So let's say you want to cut your losses. Let's say that, you know, they haven't been paying rent.
I'll get to that.
What's that?
So I'll get to that in just
okay.
a second.
I was gonna say, like, yeah, the question's like, fine, yes, I agree, the place is not habitable, let's get them out.
Yes, I want them out so that I can do the repairs. I'm sick of hearing the complaints. Like, let's just cut our losses. At that point, it may be worth your while to offer them money, which just hurts. But if they have a legitimate complaint, that's probably your best bet. Like if they're talking about withholding rent and they're going to sit in the apartment and you don't want to evict them, maybe it's worth your while to offer them money to leave. And in fact, I'll talk about this in a minute. It may be worth your while to offer people that haven't paid you rent money to get them out of your place. Just some things to know about when you get there. So you'll get to court. They'll call your case. You'll get in front of the judge. The judge will say, "Go outside and talk about it." Before he'll hear anything, you're required to go out. You guys, into the little hallway in front of the housing court room on the 4th floor of the Hennepin County District Court. They've got papers there to work out settlement agreements. So you'll talk to them for a while, and you'll see if you can come up with an agreement that'll be in both of your interests and the tenancy, and just have this go away. So think about it beforehand, what you're going to accept. So like if you know, and you do know that like basically from day 1 to eviction, you're probably looking at least 3 weeks. So if you file for eviction, if they don't pay their rent, they miss the deadline of the 5th, you haven't hauled about it for a couple of days, you're probably not getting them out before the end of the month, which means that you're not going to get somebody into the apartment. At the beginning of the next month, you're going to lose 2 months worth of rent. So think about that when you get in there, that if we're already on the 15th of the month or the 20th of the month, I might just want to cut my losses at that point and say, listen, I just want you out of here. I'll give you $500 to leave in a week, so that I can rent this apartment and just part ways. And it sucks because this person just made $500 for being a jerk, but again, you just have to suck it up sometimes. So if you win, the judge is going to give them a reasonable amount of time to vacate, so that's 7 more days, is generally speaking the reasonable amount of time that they give them. So now we're at 21 days. If they don't leave again, then you still can't change the locks, you still can't shut off the utilities, you still can't do anything. You go back to the court for writ of recovery, and then you give them 24 more hours, so another day. Then you call the sheriff, who will schedule the time to come out, which is generally 24 to 48 hours after that. And but you know, this is not a high priority for the sheriffs. And then finally, you will have this person out of your house. So you should plan, if you need to evict someone, just for your own planning purposes, you plan on probably at least 18 days. I'd say at least 2 weeks. I mean, if you're lucky, you'll get them out in 2 weeks. And that's if like everything goes smoothly and they're like, oh, I lost, see ya. Like, you know, if you're already dealing with a person who's not on the up and up, you're probably looking at about a month before you can get them out of your apartment. So plan on that and factor that into your negotiations when you're settling with them. So this is kind of the important advice. If you have a history with this person, you know what they're like, they haven't paid their rent, if you think they're gonna bail on you, file for eviction. Like, don't hesitate, don't think about it, don't call them and give them, you know, a bunch of extra chances. You know, if you're already at the 8th or the 9th of the month, you're already pushing into like losing 2 months worth of rent. If you have a good relationship with them, if they call you, you know, and give you a heads up like, hey, I'm gonna be late with the rent this month, then obviously be flexible with it. But I've seen more people lose an extra month worth of rent by waiting to file for eviction than be like, oh, I really wish I hadn't filed for eviction because they're such a nice person. Finally, recovering the amounts that you're owed, very unlikely. If you've been to conciliation court, you're probably not gonna get that money back. You can file for it, you can go there, you can ask for it. I mean, you can garnish their wages, you can do stuff, like there's ways to get the money back, but it generally costs you more to get it than it's worth to do it. I've got like 5 minutes, so I'm gonna go through some of this stuff pretty quickly here. One thing that comes up, people leave their stuff. Know about this. If they leave their stuff, it's your responsibility. You can't throw it out on the street, you can't burn it, you can't do anything with it. It's your responsibility, you gotta treat it as if it's your own. So, get the sheriff out there, have them stand there, take an inventory, write down everything that they have. List the items, date and sign it, get the officer information. You have to care for their stuff. So if you pay to put it off site, you have to pay someone to come pick it up, carry it there, store it safely, take care of it. If they ask you for it, you have 24 hours on a weekday. So if they come on a Wednesday and they say, I want my stuff back, you have 24 hours to get it back to them. If they owe you money, doesn't matter. You have to give them their stuff back. Weekends, you get 24 extra hours. You gotta store it for 28 days, unless they tell you they've abandoned it. Like if they say, you know what, I don't want any of this stuff, you can have it. Even if they tell you that, you still have to store it for 28 days. So don't just get rid of their stuff.
Even if they say it's, you can buy it from them, right?
You can buy it from them. If you say, yeah, if you go to the tenant and you say, I'll give you $2,000 for all this stuff, you sign it all over to me, you can do that. Yeah. But that's just a regular contract for stuff, right? Like it's like buying something from somebody at the garage sale. If you don't hear from them, $5.
That's what I was saying.
We'll deal with the most common situation is they're gone, they're in the wind, I have no idea where they're at. So starting from that assumption, which is generally where people are at in these types of situations, you gotta keep it for 28 days. After it's become apparent the unit has been abandoned, use your judgment, but I mean, if you haven't heard from them for a week, you filed for eviction and they didn't show up, you got the sheriffs to come out, like it's pretty clear it's been abandoned. You have 28 days, they have to hold on to it. After 28 days, you can do whatever the hell you want with it, but if you sell it, you gotta give them 2 weeks notice before you sell their stuff. So either in person or first class certified mail to the last known address.
So what if you say, you know, hey, do you want to come back and get the stuff, or do you want me to get rid of it? And they say, no, you can get rid of it. You still have to hold it?
To be safe.
Wow.
Absolutely. Because they can say, oh, you know, I was drunk, I didn't mean it. You know, he destroyed all my stuff. It was worth $20,000. Like, you know, my grandmother's priceless brooch. Like, you're safer just to follow the rules of the statute, keep it for 20 days, sell it. Yeah.
That 2 weeks, can that start in 28 days, or does that have to wait?
So it can. So you're only required to hold it for 28 days. So you can give them 14 days, give them notice you're going to sell their stuff on the 28th day, and then get rid of it. That's a good question, and I should have put that in there. Couple more points, just real quick. I've got, If you hire somebody to manage your property, make sure you do a background check on them. Make sure they're not a murderer, sex crime, sex offender, or a kidnapper. If you take pre-lease deposits, get it in writing. One thing that I just wanted to make sure to flag for you guys, if you have your tenants doing yard work, snow removal, and they're going to be using your tools, you should sell it to them. If you put if you have a lawnmower on your property, and you say, yeah, you guys are going to mow the lawn every week, go ahead and use my lawnmower, it's totally fine. They chop their foot off, you could be in trouble. So just write up a simple contract, say, I'm going to sell them this lawnmower for $20, and just have an agreement with them that they'll sell it back to you. They're going to sell it back to me for $20 on such and such a day. It's a pretty simple thing, but just to cover yourself for some of the liability. Generally speaking, just don't do it. Don't give them things that they can hurt themselves with. If you have it in your lease that they're going to take care of that stuff, just have a requirement that they provide the stuff to do it with. If you don't have a license, I don't know if anybody's ever done this or experienced this, but I did have a client that didn't have a rental license and was renting out an apartment. Horrible idea. You're liable for all the rent that they paid. You have to pay it back to them, and you can't evict them until you get a license. So basically, they are in your house. You cannot get rid of them. They're stuck there until you get a license. 30 days after that, you can start eviction proceedings. So if you don't have a rental license, don't rent things to people. People ask me about entering the property. You gotta have a reasonable business purpose if you're gonna go in there. So that includes showing it, maintenance inspections, checking on their health if you think they had a heart attack. The ones that cause problems are checking on lease violations and checking for unauthorized people. So they don't want you in there. You want to get in there. You think they're violating the lease. That is a reasonable business purpose, but it gets tricky, right? Because they have a right to privacy. They have a right to quiet enjoyment of the premises, quote unquote, under the statute. So you showing up, saying, I'm giving you 24 hours and I'm gonna, bust in whether you want me there or not. Don't break down doors, don't crawl through windows. Like, and I had this happen, right? My tenants barricaded themselves in the house. Like literally with a bar on the front door, and they piled stuff up on the back door. We knew that they were doing stuff. We knew that they were violating the lease. What's that?
It's like putting bars on the door.
Yeah, we didn't know they had done it actually because we did try to get in. We gave them 24 hours notice. We went up there to go in there. I unlocked.
These were the people upstairs?
Yeah. I unlocked the door and tried to open it, and it was stuck.
Oh my
When
God.
they eventually abandoned the apartment, a month later, when they eventually abandoned the apartment, we got in there and we could see that they had a pole, because it's, the door opens, there's a hallway right here, there's a pole in there. Anyway, don't break in. She was at the back door with a knife once, it was crazy. 24 to 48 hours notice. We already talked about this. The last thing I had was renting to family and friends. If you're gonna rent to your family and friends, make sure you charge market rates. You can get into some trouble if you don't do that. So if your sister comes to you and says, hey, that's a really nice apartment you got, can I get it for $500? Don't do it. You gotta charge, and it's generally easy to find. There are, I can't remember the name of the website that lists, fair market Hennepin County per neighborhood, I think.
Actually, Zillow will even show you what rent rates are.
Rent Tom.
Yeah.
Can you say why though? I'm just curious. I mean, I'm not with family friends, but why would?
It's mostly a tax thing. It's a gift, right? You're basically giving them something of value, and they're receiving that from you, and they're not paying taxes. Yeah. So you can be liable for the amount that they're not paying if you give it to a family member below
And
market rate.
does it show up when you file the taxes, or kind of how would it?
It's tough to get caught.
You're liable
CRP,
to
maybe.
It's
yeah.
mostly
A tax.
who enforces it? Do you know who enforces it?
I have no idea. I didn't know it was a thing. I just sold a duplex where the rent was just rock bottom, and they were renting it to family and friends.
They can get in
It's
trouble
not
for
fair
it.
market value.
I bought that duplex.
How is it enforceable? I'm just curious, because I've never, it's the first time.
I think they would catch you on the CRP. Is when I think they get you. I don't know who the enforcer is on it. To be perfectly honest with you, I've never had this come up, but my wife. My wife was like, throw that into the slide. Tell them to make sure to rent their to family members, because her sister tried to rent from us. The sister screwed up serves the process. When we moved out of the duplex, she was gonna rent it from us, and we told her what it cost. She said, well, can you give it to me for, yeah, it's $1,250, can you give it to me for $1,000? You can't. And I
It's a
should
good
just say,
reason to tell your relatives that you can't.
yeah, I should just say, like, I honestly don't know, and that's why it's the last point of my slide was because, like, as I was leaving, my wife said make sure to tell them that. I just know that it is true.
I discovered in your application that I'm related to you. That's why I'm denying your application.
So yeah, I don't know how it's enforced. I don't know who is the one that does the enforcing, but I do know that if you rent below fair market value to family, primarily family, that you can get dinged.
You can rent below fair market value to anybody else.
Yeah. It's as long as it's not your wife or your friends, your sister or your friends or whatever. Like I could rent to you for $500 if I want to take a loss on the apartment.
Yeah.
They just don't want people giving their relatives like
Preferred.
yeah.
So if you're offering it below market value to everyone, you can rent it to.
That's actually a good question.
Yeah.
They would probably still look askance at it, and like I said, I'm pretty sure it's a tax issue.
Well, I know that, like in TurboTax, it does ask, like when I've done like use the TurboTax Premier for rental, it will ask me when I go in there, it says, do you want to, double check, fair market value for your, property.
Like, am I getting fair market value? Yeah, I don't know. I can look it up, and because I know she has a citation for it. I bet if you Google it, you'll be able to find it. It's just not legal advice.
It is a tax thing. They're worried about fraud, money laundering.
Yeah, like I'm giving some. So yeah.
Still getting another fee or service for it.
Just lastly, kind of going back to if they abandon their junk and they're like, this is junk, and you don't want to hold it for 28 days. Back to I'm gonna buy it from you. So you can buy from them for $1. Like, okay, you
if they're willing to sell it to you for $1.
Yeah, buy their junk, right? They're like, it's junk, I don't want it. You're like, I don't want to take the liability of holding it for 28 days. So here, let me just give you $1. We'll put it on paper. This piece of napkin. So and so bought everything for $1.
Absolutely, you can write a contract for anything you want to write a contract for.
Okay, so that's fine.
Like I said, generally speaking, when these things come into play, it's the situation where I don't know where they went. So I can just tell you, like, and it's a pain. So we had tenants. They claimed that the house. Jordan knows the story. So they claimed that the house was full of mold. Called me or wrote me a 6-page single-spaced handwritten letter that said that the house is full of mold. We can't live here, and it's uninhabitable. And my wife was pregnant, so I went upstairs, and they were drunk. And she was in a rubber smock with no pants and a gas mask, and she was in a bathrobe with a dust mask over it, and she had a magnifying glass and a flashlight, and she was showing me spots on the walls where she said the mold was coming through. Right, so they're schizophrenic. I don't know what that was going on. They refused to leave, so we went through the whole eviction. It was a nightmare process. Anyway, when they finally did leave, it was like 6 in the morning on a Saturday. They had a U-Haul, like a tiny one. I mean, this is a 5-bedroom apartment. They had a tiny, like one of those, the smallest U-Hauls you can get. Jammed full of shit. Everything else was still up there. So yeah, my parents came, her parents came, we went up there, garbage everywhere. We had to inventory the garbage. Like, we didn't throw anything out because it's like, I mean, if you toss something and they come back later and say, that was my, vintage 1940s Budweiser bottle that you threw out in the garbage, right, and it's worth $500, then it's on you to show that it wasn't.
Well, can't you say what Budweiser bottle?
Well, I mean...
they probably did take photos of the property before they left.
No,
right?
but you don't want to get into the... I mean, it's just like insurance, anytime you have an insurance claim, I just bought a bunch of electronics.
Yeah.
Yeah, they do have to show that they had stuff and that it was worth money. But, I mean, for all you know, they had a 1940s vintage Budweiser bottle that they took with them. And then they said, I didn't take it with me, and they threw it out. I mean, unless you have an inventory that shows that that wasn't there, and you've got a cop that signed off on it, you're looking at a fight. Okay. I did not think that was going to take almost 2 hours. we didn't really get into, and I see the LLC guy left anyway. If anybody does have questions, do you have an LLC set up for your properties?
I'm required to. For one of mine, I have an LLC set up.
Oh, because of the
commercial loan.
Right.
Yeah, they require it.
For
my residential loan, I don't. I think Tim can speak more to that because they can call
They
it.
don't call it, yeah, they don't require it.
Yeah,
It's the opposite.
not that they don't require it, they won't allow it even.
Right.
So.
Plus it's a certain dollar amount, like I just went through this, like they wouldn't let me do an LLC because the house wasn't over $420,000.
Right.
Wow.
It was really bizarre, it's like, okay, so you'll give me more money and I can do it in an LLC. But you
Yeah, there's just
It's because it wasn't a so
Not a conventional
you crossed a threshold where it was no longer conventional.
That's well known, it's just that was most part of the policy or something, I don't know, it was really weird.
Yeah, it gets,
Like, 'cause
and you guys, I mean, it gets really complicated really quickly, like, when you can, yeah, go ahead.
So is it just worth it to do an umbrella policy then?
Ask your insurance agent.
I used to be one, so like,
Oh.
I kind of get how that works, but like, is that sufficient coverage, do you think?
I don't know anything about that, but I recommend everybody do it. I
Yeah.
have multiple umbrella policies.
Yeah, I mean,
And
you
that's
get
what
up
I've
to
got
like
on
5
mine.
million, not commercial, so they go pretty high.
So yeah, not to give insurance advice, which is way outside my ballpark, but yeah, that's what I've got on. We've got the 2 properties and we've got an LLC just because, like I said, in case somebody cuts off their foot, I don't want them coming after my other house. But yeah, you should have plenty of coverage with the umbrella policy.
A $1 million umbrella policy is like $95 for you personally, and then for a commercial, mine's $290 or something for $1 million commercial. So it's totally worth it.
A month?
No, a
No,
year.
per year.
It's not expensive.
They're really cheap. And a lot of times you
Yeah.
get multi-policy discounts off your
Oh, yeah.
home and auto too.
Yeah, for the peace of mind that it gives
you.
you, it's like, get as much insurance coverage as I mean, obviously, like, don't go overboard on it or anything, but for the price, it's like, it's sweet.
Yeah, and then you have the insurance company defending you.
Yeah, that's the other thing, is they'll pay attorney's fees. They will, if you have to defend yourself in something, that sometimes the policies will cover that, or they'll provide the attorney's fee, or them to do it.
It's really worth it.
Excellent.
Thank you.
Awesome. Thank you so much.
No, it's interesting, the FHA stuff, we're actually, we're suing, we're suing, I would think,
So I had a similar situation.
Hypothetically, we have to deal with it tomorrow.
So what I did is I told the people that not
yeah, several lawsuits are living
why not keep the steering deposit, and I'll try to get some else in there. And I'll refund the bill.
Yeah.
Yeah.
Well, and then it sucks too, because we like, we held it for like 2 weeks with them, and then we're like, okay, so we'll charge them a little bit more monthly rent, they're fine with that, so it like kind of evened it out, like we lost a little bit, they lost a little bit, but at least we like didn't have to go through more tenants or whatever.
Yeah.
And then, yeah. So yeah, it's like, a month.
No, they're required.
Oh, yeah.